Hello everyone. So I'll be talking to you all about administrative law, which is a second year compulsory subject. And firstly, I'll be discussing about what administrative law is. And secondly, we'll be discussing on why and how administrative law evolved in Sri Lanka. And thirdly, we'll be discussing the constitutional evolution of judicial review as administrative law in Sri Lanka. So, getting straight to our points, let us start off by understanding what administrative law is. So, administrative law is basically the law that regulates the exercise of power by governmental bodies. So, administrative law basically brings out judicial review in Sri Lanka. And then the question arises, why do we need judicial review? So, now say the state has sovereign authority and the state functions through three main organs, the executive, legislature and the judiciary, where these three main organs form the government. So the state sovereign power is delegated to the government and becomes governmental power, and it is exercised over the people on behalf of the state. So govern the government and the governmental bodies which fall under the government, which derive power from the government to exercise such power over the people, makes decisions which affects the rights of the people. So such power, such governmental bodies were granted unlimited power to exercise their power over the people. So there was a necessity for a mechanism to regulate the exercise of power by these governmental bodies. And that mechanism, or those checks and balances, are brought through judicial review. And judicial review is exercised through administrative law. So that is the purpose of administrative law, that it is to place checks and balances and to regulate the exercise of power by governmental bodies. So administrative law is exercised through writs, and these writs originate from English law. Administrative law itself originates from English law. So basically, the main source of law for administrative law is the Constitution, Article 140 of the Constitution, Article 140 and 141 of the 1978 Constitution, which grants power to courts to issue orders in the nature of writs. For writs such as writ of certiorari, prohibition, writ of mandamus, writ of quo warranto, writ of proceedendo, and writ of habeas corpus. So these writs are the orders in the nature of these writs are issued by courts to bring out judicial review or to review the decisions made by governmental bodies. So unlike other laws, administrative law is based on and built up on case laws. You can't find any act of parliament or other statutory authority which lays down a comprehensive document about the application and the use of administrative law. Because administrative law originates from English law, even in Sri Lanka, administrative law is based and studied and built up on case laws, on English and Sri Lankan case laws. So the doctrine of stare decisis also comes into force, and certain court decisions or court cases which has been decided during that time period stands as the prevailing law or the governing law of administrative law for that time period in that particular state or nation. So I basically covered my second point as well, why and how administrative law evolved in Sri Lanka. And let us move on to our third point, which is the constitutional evolution of judicial review as administrative law in Sri Lanka. So, administrative law, when this necessity for the mechanism of checks and balances or regulation over the decisions made by governmental bodies arise, then administrative law was introduced into Sri Lanka. So for the first time, administrative law was introduced to Sri Lanka through the Courts Ordinance, which was established in 1956. So section 42 and 45 of the Courts Ordinance granted power to Sri Lankan courts for the first time to issue orders in the nature of writ of certiorari, writ of prohibition, mandamus, writ of prosedendo, writ of quo warranto, and also writ of habeas corpus as judicial review, reviewing governmental decisions made by governmental bodies. So these provisions in the Courts Ordinance, section 42 and 45, are explained well in the case of Naukudali versus Jayaratna, which is a landmark case which is crucial in learning administrative law in Sri Lanka. So before reading section 42 of the Courts Ordinance, we must also look at the English case R versus Electricity Commissioner, where an English judge has stated the words which created the main influence actually for judicial review, and these sections incorporated in these ordinances in Sri Lanka as administrative law has been directly influenced, has been originated from the influence of that dictum stated by the English judge in the case R versus Electricity Commissioner. So in the case R versus Electricity Commissioner, Lord Justice Atkin states that whenever any body of persons having legal authority to determine questions affecting rights of the subjects and having the duty to act judicially act in excess of their legal authority, they are subject to the controlling jurisdiction of the King's Bench Division exercised in these writs. So this is the dictum which influenced the creation and basis for judicial review, and that judicial review which was created is exercised through administrative law, which means is exercised through writs. And so the power to grant writs, as I said, was for the first time granted to courts by section 42 and 45 of the Courts Ordinance incorporated in 1956. Section 42 of the Courts Ordinance reads as follows: the Supreme Court or any judge thereof at Colombo or elsewhere shall have full power and authority to inspect and examine the records of any court and to grant and issue according to law mandates in the nature of writs of mandamus, quo warranto, certiorari, prosedendo, and prohibition against so on, against public bodies, and so on. And section 45 of the Courts Ordinance grants powers to courts to issue orders in the nature of writs of habeas corpus. So in this section, the phrase according to law is a crucial phrase, because in the case Nakudali versus Jayaratna, an argument was brought that the phrase according to law in that section meant according to statutory law established by the Parliament of Sri Lanka, incorporated by the Parliament of Sri Lanka. However, the judgment of that case came out, and the judgment of that case confirmed and decided that the phrase according to law in this section does not refer to the statutory law incorporated by the Parliament in Sri Lanka, but refers to English law, because administrative law has originated from English law, and therefore in order to make determinations based on administrative law, the law relating to administrative law is always English law. So therefore from the phrase according to law, the incorporation or this statutory authority has referred to English law and not the other statutory authorities or acts of parliaments. So this was confirmed in the judgment Nakudani versus Jayaratna. And then so with this power, state continued, and in 1972, when the first Republican Constitution was created, the same power which was granted to courts, the same writ jurisdiction which was granted to courts to issue orders in the nature of writs, was given through the Administrative of Justice Law Act, which was enacted in 1973. And under Administration of Justice Law, under Section 12, all the powers which were given in the court's ordinance was also granted. Mind you, in both these acts, in both these sections, power to grant writs or writ jurisdiction was given to or granted to the Supreme Court of Sri Lanka, and the Court of Appeal had no part in it. So then, coming through this evolution, finally, in the year 1978, when the 1978 Constitution was enacted, the 1978 Constitution itself included the power, granted power to courts and in vesting writ jurisdiction in courts to issue orders in the nature of writs as judicial review, to review decisions of governmental bodies. So the significance of incorporating Article 140 of in the 1978 Constitution is that the power which was given to courts to issue orders in the nature of writs was directly granted to courts through the Constitution itself, without being issued indirectly through statutory authorities or ordinances or acts. And also, for the first time in Sri Lanka, the power to issue orders in the nature of writs, the writ jurisdiction was vested in the Court of Appeal, was taken out of the Supreme Court and vested in the Court of Appeal. So, Article 140 of the Constitution, 1978 Constitution, gave powers to the Court of Appeal to issue writs, all the writs as Section 42 of the Court's Ordinance in 1956. And Article 141 in the 1978 Constitution granted power to the High Courts to issue orders in the nature of writ of habeas corpus. Also, in 1987, the 13th Amendment came into being. And through the 13th Amendment, Article 154p was incorporated to the 1978 Constitution. And through Article 154p, provincial high courts were established in the 1978 Constitution. And these provincial high courts established under Article 154p was also granted provisional writ jurisdiction in relation to all writs, including writ of habeas corpus, to be exercised provisionally in accordance with the provincial council laws and provincial council list, etc. So those are the three main articles in the 1930 Constitution, which is relevant for administrative law and which grants courts jurisdiction and power for judicial review. So we see it has to be observed that judicial review in Sri Lanka was and is being exercised by writs or by orders issued by courts in the nature of writs under Article 140, under Article 141 and under Article 154p. And also there is another way how judicial review is exercised through courts, and that is through Article 126 of the 1978 Constitution, and that is the Fundamental Rights Action. So the purpose for the emergence of judicial review, as I said before, was to review and keep the public servants or tribunals who are vested with unlimited powers to make decisions affecting the rights of the people and to exercise their powers within their limits and legal bounds. So this way there has been a constitutional evolution, and judicial review has evolved throughout this evolution through administrative law under the exercise of orders in the nature of writs. There is a reason why courts, what Sri Lankan courts issue are not writs as such, but they are called orders in the nature of writs. The reason for that is the orders which are issued by courts are not those original English writs as such, but they are orders based on the Sri Lankan laws which are in the nature of those English writs. So that's why the orders issued by courts are known as orders in the nature of writs and not known as writs as such. And also there is a main reason. If we look at the evolution if we look at the constitutional evolution of administrative law, there is a reason why initially the power to issue orders in the nature of writs to court to interfere through judicial review has been granted to courts through ordinances and acts like the Courts Ordinance and the Administration of Justice Act. And later on in 1978 in the Constitution, there is an article incorporated in the Constitution itself granting power to Sri Lankan courts to exercise judicial review through orders in the nature of writs. The reason for that is because certain public authorities which has been established under statutory authorities or acts of the Parliament have derived power, unlimited power to make decisions affecting the rights of the people. And in such statutory authorities or acts of the Parliament, there are clauses you can find which precludes or ousts the court from interfering through judicial review and from reviewing the decisions made by such public officers who have authority under such statutory authorities. So, for an example, the Control of Textile Regulations Act 1945 also has a preclusive clause or ouster clause which states that the court cannot interfere with the control of textiles decisions and therefore excludes or tries to preclude court from exercising judicial review and from reviewing the decision of such public officers. So these are called ouster clauses. So the problem which occurred initially with the writ jurisdiction in Sri Lanka was that the power to issue orders in the nature of writs were granted to courts in Sri Lanka through statutory authorities or acts of Parliament, and there you find other acts of Parliament or statutory authorities which also brings clauses such as ouster clauses or preclusive clauses stating that the court cannot interfere in any manner in review, and the court cannot review the decision made by such public officers. So these clauses and the statutory authorities came into collision, and there was a problem there. So to prevent that, since the Constitution is the highest law, is considered the highest and most prevalent law over all the other statutory authorities in a nation. In the 1978 Constitution, the power to grant orders in the nature of writs was granted to courts from the Constitution itself, directly granted through an article in the Constitution, and that's how writ jurisdiction was vested in the Court of Appeal through Article 140, Article 141, and Article 154p. So that was the reason for the change of legislation with the constitutional evolution of administrative law. So therefore I have covered all three of my points, and we have come into conclusion. So yeah, thank you so much for giving me a patient hearing, and hope you'll succeed in all your studies. Thank you very much.